Hi, my name is JaqulinJuarez, and my IPP is on common law. I'm going to be talking about what common law is and where common law originated from, as well as the development of common law through time, as for its influences and who and what did that for common law, and a little bit about common law such as equity, judicature acts, and stare decisis, offenses, and how the U.S. adapts to common law, as well as common law internationally, and how common law is used today. So common law is more so known as a traditional law of an area of or region, also known as case law. The law created by judges when deciding individual disputes or cases. The body of law, which includes both the unwritten law of England and the statutes passed before the settlements of the United States. Common law is like, it goes case by case and it develops as these cases are judged. So it started around the 9th century Britain from Alfred the Great. He ruled between 871 and 899, and he brought his own set of rules with him as he conquered England. And as him and the other Normans tried to bestow their customs onto the seven kingdoms, it was a little bit difficult because each tribes had their own traditions on how they settled disputes and punishments and just took care of payments and compensations to victims. There was little control over the courts because everyone was so different, but there was also courts such as the manorial and the shire and our court, but as well as the county court. In the year 1066, it was known as the inauguration of the common law tradition. So William the Conqueror won the Battle of Hastings and defeated the English, and he had merged with the Normans' laws and customs. They were very accepting towards their customs. And they happened to centralize administration at Westminster and ended tribal rule. So royal courts were created, and it really helped build a foundation for common law in all of England. And what people did is they all went to seek King William or his other court officials for matters to be judged and sought to be brought by justice. And it also began to form through the king's judgments and whatever he thought was in his piece. And of course, it went on case-by-case basis. And during the 13th and 12th century, it was the early development of the common law where the system truly began. So the reign of King Henry II really led to a whole systemizing of common law and laid down some pretty good foundations. Everything became more clear-cut and unified throughout England. And most serious crimes, also known as felonies, were homicide and theft. Those were predominant. And so they were no longer able to settle them themselves within the tribes, and criminals were very, very hard to catch unless they were caught red-handed or in the act of actually committing the crime. But when they were caught, they were always dealt with as soon as possible. These punishments for things such as thief were usually very harsh, such as death or beheading or hanging or even mutilation. And a lot of these trials were determined guilt by ordeals, which included cold water, where they had to sink or float to determine whether they were guilty, or by a hot iron, which they had to hold a hot iron bar, and if they were burned, it meant that they were guilty. Of course, these were not very effective, so later on they decided to do trial by combat or trial by battle. So eventually, in the late 12th century, common law was written down and explained and distributed throughout England in a text called Glanville. And the text was written anonymously, so we don't really know who wrote that quite. and common law and civil law were very clearly distinguishable by this time. And this is also the time where the Magna Carta was created, and it became a document that helped keep common law upheld as well as protected certain laws within common law. So about common law a little bit. Common law always includes equity. Equity has to go alongside common law to help mitigate situations and rulings. And the Chancery Court assists in this by ordering injunctions for people who are mandated by the court to do things. So the Judicature Act of 1873 assures that both common law and equity are applied to cases equally. And whenever there is a conflict between common law and equity, equity always prevails in any conflicts. So then we come to stare decisis, and that is the power and obligation of the courts to base their decision on prior decisions. This notion helps define common law. So through this, it's a judge-made law. That means that judges go by case, and they always go with their prior decisions to refer to next cases, and it helps them determine outcomes. And also the force of precedent, which produces positive statutes and laws and court rulings, and it also stays partial to some of England's law, even after the Civil War taken place over by legislation in the mid-19th century. Common law also has its own offenses, such as offenses against common laws can only be punished by common law countries. So in the United Kingdom, offenses such as murder are defined as judged by the common law system instead of by statute, because they have a jury court. And so most U.S. states have enacted criminal codes or statutes to determine punishments for crimes and are, of course, judged by judges. And you cannot be held in contempt of court in non-common law countries, because non-common law countries do not have judges, therefore do not have the power to hold someone in contempt of court. Early American settlers brought with them the English common law system and tended to base their foundation off of what they already knew, because they did not have it written down at the time. And basically it was very easily, as long as it didn't conflict with the English law, because they were not yet independent, then they didn't really have any problems with England. But this had some problems with the 13 colonies, because each one was created in a different time and had different royal charters that were assigned to them. So as they grew economically and socially, of course, it became more unified and easier to access common law and let it be established. So by 1776, in the independence of the U.S., everybody was more unified, there was more lawyers, everybody was able to establish better unification when it comes to common law, so it was easier to practice it among the country. So by the end of the 18th century, all kinds of publications from common law, such as Blackstone's Commentaries of the Laws of England, became distributed around America around 1803 or so. And all U.S. states really follow common law except for Louisiana, because it was part of the Louisiana Purchase and basically follows the French Civil Code. So that's the only state in the U.S. that does not follow common law. Around 1829, Harvard Law School was established, and the scholars that graduate Harvard Law School and professors that work at Harvard Law School help to determine what the U.S. common law system should be, and they help to develop that within our country. And we are pretty different still from England's common law, because we have separate constitutions and legal systems and laws for each state, as well as federal constitutions. And the U.S. system also has a judicial review that isn't as limited as England's review. They also have other differences, such as their trial practices and the weights that the scholarly opinions have and hold on different laws, and also the backgrounds of the judges and their methods and the way that they handled their courtrooms. And common law isn't just practiced in the US and England, it's also practiced in Australia, Canada, and African countries colonized by the British. There are a couple of examples that show where common law is applied internationally, and another one of those is there is a group or an organization called the International Common Law Court of Justice, and these people, they help people internationally who go through war crimes and genocides and other terrors and just illegal humane acts across the country. And they helped once by prosecuting 30 people in Canada for the genocide of Indigenous children that lived in Canada in 2012. And another example of how common law applies internationally is that there is a parens patriae that is practiced among common law countries that basically says that the state has the ability to be the ultimate guardian over children, especially when it involves their welfare. In February of 2019, as an example of how common law is used today, the UK Parliament passed the Voyeurism Act, and this act came into effect because of an incident of a rise in the UK of an activity called upskirting, which involved people putting cameras in between women's legs without their permission. And this was seen as outraging public indecency, which is against common law. And this is the reason why this act was implemented last year. And there are also some current issues that involve common law. These issues concern debates and difficulties that people are having because of what's going on with COVID-19. Like, for instance, people are claiming that the reason that they have to close down their business is invalid because it imposes on their rights according to the Magna Carta to resist any unjust government doing. Another struggle involving common law is the doctrine of frustration and possibility. It pretty much gives lenience on both parties of the government and business owners who have contracts with other businesses. It just gives leniency and a little bit of monetary extension through this time because it is neither party's fault. So that helps everybody out a little bit. But there are many issues involving common law today, and of course common law keeps changing every day. As long as its system works properly and just, it will constantly change, hopefully for the better, because this involves what our judges ultimately think is right and their prior experiences and future experiences as situations in modern society keep changing. Thank you for watching.